Be ready. Start. The changes brought about by new statute, that is by section 163A of the Act, appears to the only in respect of the mode and method of enforcement of right to receive compensation, and it has nothing to do with the creation of any new right or obligation in respect thereof. Therefore, the aforesaid provisions merely dealing with the new method of enforcement of rights existing under earlier existing statute. It does neither create any new right or obligation, nor impose any liability, nor takes away or impairs any vested right acquired under existing law. Thus, as distinguished from the statute dealing with methods of establishment of the rights. Thus, the provisions contained thereunder appear to be nature or remedial statute, which is also a procedural in nature, providing method of computation of compensation and method of pleading and standard of proof of the claim, and cannot be held to be statute dealing with substantive rights. In this view of the matter, presumption as to prospective operation of a statute does not apply to an enactment affecting procedure or evidence. The reason is that no person has a vested right in any course of procedure. The general principle indeed seems to be that alterations in procedure are always retrospective unless there be some good reason against it. In view of the aforesaid, there can be a little scope for doubt to hold that since the provision contained under section 163A cannot be said to be a statute dealing with the substantive rights, rather contains statute relating to procedure and evidence, therefore presumption as to prospectively of the statute does not apply. Assuming for the sake of argument that provisions contained in section 163A(1) are substantive in nature, as it confers new favor or remedy and creates new obligations, even then the intent of legislature can be gathered from language employed under subsection 1 of section 163A and object sought to be achieved by it, wherein the legislature by using non-obstant clause has clearly mandated that the owner of motor vehicle or authorized insurer shall be liable to pay in case of death or permanent disablement due to accident arising out of use of motor vehicle, compensation to the legal heirs or victim as the case may be, without any cut-off date as to whether the accident occurred prior to the date of commencement of the aforesaid provisions of the Act or on or after the commencement of the Act. It implies that the mandate of legislature can be complied with only when claims tribunal award compensation to the victims or legal heirs in situations visualized under the provisions of aforesaid section. If the claim tribunals would refuse to award such compensation, keeping the view in mind the date of commencement of the aforesaid provisions vis-a-vis date of occurrence of the accident, they would certainly defy the clear mandate of legislation in this regard. Therefore, provision of section 163A will apply even in pending cases before claims tribunal as well as in pending statutory appeals at higher forum including High Court.